SJC-12008, Commonwealth v. Marcel Diggs, and SJC-12009, Commonwealth v. Damian Soto.
Good morning, Mr. Crane. You're going to show us what all these folks are missing, huh?
I'll try.
Go ahead.
Good morning. May it please the court, Edward Crane on behalf of Damian Soto and Marcel Diggs. Resolution of this case largely depends on one question. How do we define an absurd result for purposes of interpreting statutory language? The language at issue here requires that a defendant be held under arrest for a qualifying offense in order for a 58A dangerousness hearing to be held. A defendant who is not held in this manner cannot be subject to 58A. The statutory language can only be ignored if the result would be absurd. The Commonwealth argues that it would be absurd if it could not hold dangerousness hearings for both of these defendants.
Well, let me ask you this, though. Mr. Charles argues that you need to read paragraph 4 with what precedes it, and if it is, so it's a crime if there's an arrest, and both of your clients were arrested. I understand that at the time of the court they weren't under arrest, but they had been under arrest. So if you read those two parts of 58A together, does it deal with the absurdity? I mean, it makes it. In other words, it seems to me that it depends on when are you talking about under arrest.
I think that if you read Section 1 does not help clarify the held under arrest language, and my brother argues that you could interpret Section 1 to stand for that certain crimes you need to be arrested for and certain crimes you simply need to be charged for. But again, that would make the language in Section 4, which is really at issue today, completely irrelevant. It would read it out of the statute.
Well, suppose somebody was held under arrest, was arrested, let's say, as in the case of one of these defendants.
They both were, actually.
Couldn't one say the fact that they weren't being held at that moment is sort of not really contemplated by the entirety of the statute, but the fact that they were arrested is?
Yeah, that's what I'm trying to say, but it was much better said over here.
The arrest was a historical event, and that's enough.
Even better.
I think the plain language is held under arrest.
That's that one section.
Yes.
I mean, you look at that statute, and there's all kinds of language about charged and arrested, and you know. I mean, you got to look at that in the context of the entire statute. You can't look at it just by itself.
Yes, and I think that if you look at Section 1, and this is where those other sort of precursory language, those phrases come from about custodial status, I think that the only way you can read those phrases are that they're typos. Because if you read subsection 1...
Typos,
in legislation, typos?
Well,
almost unprecedented.
It starts out okay.
To reflect that that meant to be sarcastic.
Section 1 starts out okay. Commonwealth may move based on dangerousness for a felony offense. So that 4 is when it starts to enumerate the different offenses.
So why should a defendant who can make bail be treated differently from one who can't? That doesn't make sense to me. I mean, if the legislature's purpose was to make sure that people who are considered to be dangerous be treated as required under 58A, and given your interpretation of the statute that the person isn't actually being held when they show up in the courtroom for arraignment, isn't that an absurd result?
No, I don't think it's an absurd result, because I think what we have to look at is there is a distinction between someone who has been released and someone that's being held at the time. And
well, what's the distinction other than they have the cash and they were able to find a bail commissioner and a bail bondsman to come to the police station at night.
Well, as a practical matter, they have to return to court. That's the main distinction. They have to make the decision to come back to court. They
So
have
the
been
fact
released.
that they decide to come back rather than default spares them the 58A procedure.
Yes, and I think that is, it can certainly be rationalized why that would be the case. And
It precludes the court from making a determination of dangerousness, the fact that they showed up voluntarily, which is, I guess, what Mr. Soto did in this case, right?
yes,
What if the person defaults after posting bail and then is arrested on a default warrant? It's not for the offense under the meaning of the statute, under the language of the statute, but he's then brought back into court under having been arrested.
that's an interesting question, but I think in that case, that person would be held under arrest for the offense charge.
Is there anything that prevents a police officer having, or with knowledge of an outstanding warrant that would qualify under this statute, from arresting a defendant inside the courthouse? And I'm not, let's just say the court is not in session, there's nothing, he's not disrupting a session, but the defendant voluntarily shows up to the courthouse. There is a warrant outstanding for his arrest for one of these qualifying offenses. Police officer is aware of it, sees him in the courthouse, and arrests him in the courthouse. Is there anything that would prevent that from happening?
No, and I think in that situation, 58A, under the plain language, would certainly apply.
What about the situation of the person who's in custody on the probation violation and is brought to the Waltham District Court to have the default warrants removed? Why would they have to be removed? Could he not be arrested at that point?
Well, at that point, when he was
On the arrest warrant that's outstanding for the qualifying crime?
I think that gets into a little bit of how do you technically define whose custody they're in. He's in the custody of Plymouth County Sheriff's Department, and he's being brought in via HABE. I don't really know what
And it's not ordinarily done, but why couldn't it be if your view
could
of
be
the
done.
statute is correct?
I mean, I think that, I was, in writing the brief and researching this case, I was trying to think if that's something procedurally that could be done, where he would be brought in and essentially, as a technical matter, he would have to be taken out of custody of Plymouth and transferred to the custody of the police department, and then those arrest warrants, then he would be technically held under the arrest warrants, and 58A would apply.
So if the warrant were lodged at the House of Correction where he was held, that might make a difference.
Yes, I think if it was a situation where he didn't file the motion for speedy trial, and then at the end of his sentence, he was being released, and there was an arrest warrant lodged at the House of Corrections, and he was picked up on that arrest warrant and brought into Waltham, then certainly 58A would apply, because he would be held under arrest for that, for the crime.
Now, usually, we interpret the legislature to be sensible and to do something and to follow their intent. Why should we not simply interpret this to say that if you were arrested for a crime delineated in 58A, that's sufficient? If you were summoned in for a crime under 58A, that's not.
I think this is where it comes down to how do you define absurd, and I think that you can rationalize why they would have exempted someone who has been bailed out and released,
But why? I mean, we're talking about dangerousness. We're not talking about likelihood of return. You can
these
be,
people
I
have
mean,
been-
we've got many domestic violence concerns about somebody who may very well be likely to return because they think that the alleged victim is going to be too frightened to testify. So they may return, but you may be worried about what happens in the interim.
Certainly, I think it comes down to, could the legislature have a rational basis for exempting these individuals? And I think that you could, because the legislature could have decided that, look, there's going to be situations where dangerous individuals are released on bail pending arraignment. And the legislature may have rationally decided that it's more important that we get these people to come to arraignment. They've been released on bail, but if they know that there's a threat that they'll be detained pending trial based on 58A, they may not show up, and then they'd be an individual, a dangerous individual who's basically on the lam in the community. So I think, you can argue whether that's sensible or not, but I think it's, at a minimum, it's certainly a rational justification for why you might exempt people who have been released on bail, like Mr. Soto.
Is it the case in terms of domestic violence that the statutes now, not this one, but that statutes do, basically, they don't let you get bailed if you're arrested at night?
Yes, there's special exceptions for cases involving abuse.
Right, but that was not in effect when 58A was enacted.
No.
So that can't have been in the contemplation of the legislature as of then.
No.
But, it seems to me that your interpretation, though, is going to, one effect may be that it just makes bail commissioners put the bail high enough so nobody could possibly make it, if they're worried about the 58A piece.
And
right?
they're technically, as we know, they're technically not supposed to consider dangerousness.
Well, I understand that, but that's why it's a somewhat absurd, it's circular, because you could say, well, somebody feels like they're forced to do that because they consider the crime to have been one where dangerousness is pretty obvious, and but they also know about paragraph 4 in 58A.
It could happen, but that would be, and we're hypothesizing about a situation where a bail commissioner essentially considered conditions that he's not supposed to.
So we are here because the legislature chose to craft this by saying when a person is held under an arrest for an offense listed in subsection 1, as opposed to saying when a person has been arrested for an offense listed in subsection 1.
Yes.
That's what this whole case is about.
Essentially, yes, and I think that as I point out in my brief, the legislature is clearly aware of this situation, and in the last 4 sessions, there's been bills in front of the legislature to amend this language. They just haven't taken any action on them. I think that would, just as a matter of separation of powers, I think that would suggest that the court should not step in here. And I don't say that in that being that the legislature is showing its intent not to change the statutory language, but rather that they're aware of it, and it very much would be the court doing the legislature's job for it if the court were to step in
When
here.
we think that the legislature did what it did not mean to do, we don't generally say, we know you didn't mean to do it, but that's what you appear to say, and therefore you're stuck with it.
Again,
We basically say we're going to interpret it in the manner that you intended it to be written.
I think that this is a case where it's not clear that the legislature didn't intend to do this, because I think that where you have to draw the line is there are a line of absurdity cases where, frankly, if you look at them, there's no question about absurdity. It can't even. It's barely even a discussion. A case where criminalizing leaving the scene of an accident and the reason for leaving is irrelevant if it just caused an injury, whereas if it caused death, then there's an exception.
To some extent, isn't absurdity in the eye of the judicial beholder?
Yes, certainly.
So, it's not impossible to see this as an absurd result here.
But again, I think that you have to, in defining an absurd result, it has to be a result that simply cannot be rationalized in any way. And I think that...
Well, I think, what about the example that the hypothetical that the Commonwealth gives, the 3 joint ventures, all of whom have different fates under dangerousness hearing law as you've construed it, either because one was never arrested, even though there's an arrest warrant, one got bailed, and one had the misfortune of being actually taken into custody.
And I think that as a practical matter, though...
All 3 of them could be equally dangerous.
Correct, but as a practical matter, their situations are different. In the case of the second individual, he's been released on bail. So
that person had the money to be released on bail. So if you're poor and you can't get out on bail, that's a justification for treating that person differently.
No, I don't think so. I think it's...
No, that person has been arrested.
I think the practical concern is that the person has been released. That's where the
The
practical
fact that he shows up again means nothing.
The fact that he shows up again does not relate to dangerousness, but the fact that that there's a threat of pretrial detention, that if he is aware that he could be detained pretrial based on dangerousness, he's on bail. He may never show up for court, and then the protections
If he doesn't, he
58 are
doesn't,
irrelevant.
right?
What's that?
If he doesn't, he doesn't. That's the social policy that we're supposed to be promoting by
Well, I think
interpreting
it-
it the way you think is sensible?
I think what it comes down to is, I'm not saying that this is the best way to do things. We have to say that could be no rational justification for this. And I think that you
No
can't justify.
rational justification.
No rational justification. There's some other language about absurdity. I quote in my brief that's a little heavier than that, but I think it's
Nice,
as a
poetic.
more simple matter, I think it's just no rational justification. And I think that this case really best fits the line of cases where the court has sort of nudged the legislature to fix a statutory issue, but not gone as far as to change it via a judicial opinion.
Okay, thank you.
Thank you.
Good morning again, Your Honors. Jamie Michael Charles, Assistant District Attorney for Middlesex on behalf of the Commonwealth. At issue in this case is whether Chapter 276, Section 58A should be interpreted in contravention of common sense and clear legislative intent in an overly strict manner that essentially blunts the ability of judges to protect the public.
Well, wait a second. I mean, if we're doing a plain language analysis, don't you think the defendant has the better part of the argument?
I don't believe the defendant has the better part of the argument because a plain language analysis as an
The
initial
words
matter,
held under arrest, held
plain language of a
under
statute
arrest.
will only control where it is unambiguous. And I would submit that
Held under arrest is ambiguous?
I would submit that the numerous varying interpretations by the trial courts and by the single justices of this court in interpreting those trial court decisions suggest that there is no clear common understanding of what that term means in the context of this statute. Commonwealth v. Hurley, Commonwealth v. Yakubu. In 1995, mere months after this statute was
I don't think the fact that two
enacted.
people disagree on something creates ambiguity under our cases.
Well, this court has actually held somewhat to the contrary. This court held in Northeastern Medical Center versus Commissioner of Revenue that a statute is unambiguous if virtually all reasonable people would fairly attribute only one meaning to it. And I think there's no circumstance in which this court can conclude that even the justices of this court have one unified meaning as to what held under arrest means in the context of 58A. There have been varying interpretations of whether an arrest warrant is sufficient, whether being released on bail voids the ability of a judge to make a public safety determination. There's been constant, I mean, that's why we're here. There's just been no agreement among anyone as to what this means. So the only way that we can say that the meaning is clear is if we ignore all of these other statutes of construction and the larger driving force of legislative intent and say, well, the definition of arrest in Black's Law Dictionary is X. And it's not that simple. Plus, as this court noted, my brother is viewing this singular term, which doesn't appear until paragraph 4 of the statute, in isolation. He's not viewing the meaning in the context of the larger statute as a whole. But I would just say, returning to the absurdity analysis, with regards to my brother's proposed standard, there's no language in Massachusetts that supports that conclusion. In Massachusetts, it's very clear that legislative intent is a key consideration in determining whether a statute is absurd. And the legislative intent underlying the passage of this statute undoubtedly is public safety and the ability of judges to make preemptive decisions about the dangerousness of an individual to protect members of the public. There is no indication in legislative history or otherwise that the issue of defendants defaulting or the manner in which a defendant appears in court has any relevance whatsoever to this issue, which was the driving force behind the statute, and that is, are these individuals dangerousness? Do we need to hold this individual who is a serial abuser to protect his victim?
But you won't contend, will you, that just being charged with a qualifying crime is enough?
I would agree with that with one caveat. I think if you look, and the Commonwealth made this argument in its brief, in paragraph 1, there's a delineation between crimes that require that you be arrested and charged, and certain crimes such as felonies that involve as an element the use of force, or that create a substantial likelihood of harm, for example, in which there is no arrested and charged language. But as a general matter, I would agree with you. Just being charged with a qualifying offense for the majority of the offenses listed in subsection 1 is not sufficient. And the Commonwealth's argument is not that that's sufficient. The Commonwealth's argument is simply that this court should adopt a reasonable interpretation in the context of the whole statute of this term that is in dispute, and that reasonable interpretation would be if you are charged with one of these offenses and then an arrest warrant also issues for your arrest, or you were actually arrested and then released.
Yeah, I was going to say, I mean, you, on page 13, you spoke only about a warrant issues for his or her
And
arrest.
I do apologize. That was an oversight on the part of the Commonwealth. I think
I assume you mean
being
if
arrested
a police
obviously
officer
would be
arrests you
sufficient.
or
yes.
with or without a warrant. So the
Yes.
warrant doesn't matter. It's the arrest that matters.
That's correct. And I believe that the point the Commonwealth was trying to make is that at a bare minimum, this court should expect that an arrest warrant had issued in addition to a charge. Because if we're just going to summon someone in and say, see you in 30 days, that substantially undercuts the rationale that this individual is a danger to the community. Because if the Commonwealth or the police departments do not see fit to try and take this person into custody, then there's obviously not a larger concern about their dangerousness. But where an arrest warrant issues, for example, the fact that law enforcement officers, for whatever reason, are unable to detain someone because they're homeless and hard to find, because they're actively avoiding apprehension, because they're committing new crimes in other jurisdictions and getting arrested, that should not preclude, and the legislature cannot have intended that would preclude the Commonwealth from moving for a dangerousness hearing when that person arrives.
Unless you have the person in custody, you're not going to have much of an ability to proceed with the dangerousness hearing, right?
Well, that's certainly true, but
But I mean,
at the point they
so why
are,
couldn't they be arrested before you seek the dangerousness hearing, including well, the suggestion that I was making before is maybe you don't have an opinion about this, but why couldn't, in the instance of the person held in custody on the probation violation who's being transported to Waltham District Court, why couldn't the arrest have been made at Waltham District Court on the qualifying offense?
I think there are
As
2
opposed to
points.
just having
There-
the arrest warrant removed, which is why presumably he
2
was brought
points,
there.
2 points in response. My brother interprets the statute to require that a defendant be formally arrested, that is, taken to a police station, booked, and then brought to court. As was demonstrated with Mr. Diggs, where he subsequently committed new crimes in the courthouse after being arraigned by assaulting court officers and threatening to kill them, the officers of that jurisdiction of the Waltham Police Department were not able to formally arrest the defendant because Plymouth County would not cede jurisdiction of him. So they were forced to simply take out an arrest warrant. They were not able to physically take custody of Mr. Diggs and transport him to their police department for booking and formal arrest. So that, I would say, undercuts that argument.
Under what authority is that?
I don't have a statute to
And
point
maybe
you
the
to.
practical effect, but I'm just, is there a reason legally why?
Well,
they
I
couldn't
think
do
the
it?
more practical point is that is irrelevant to the larger issue of what the legislature intended. The construction of this statute cannot be contingent on the fact that we could have police officers arresting people in court.
Well, it could be contingent on a requirement that you actually have arrested the person for whom you seek.
But it doesn't address all the shortcomings of adopting such a narrow construction. For example, everyone
Not
who
as
is
narrow as
released
the
on
one
bail.
that you actually have to have them held under arrest.
But anyone who is released on bail is not held under arrest.
No, I
at the
understand, but
time
will
they
have been
arrive, if-
arrested.
as the defendant
Will
interprets
have been arrested, and it'll be the first appearance in the court for arraignment.
But the ability of an officer to arrest somebody in court, it's often the case that the police are not present in court when an individual shows up for arraignment. It's just not, often that requires overtime, it requires additional manpower. We cannot base our construction of the statute on a suggestion that, well, if police officers wanted to, they could constantly have officers present at court to arrest any individual who shows up and hasn't been arrested yet. The construction of the term, if you interpret it as the defendant suggests, that it requires that somebody be in physical custody, it essentially creates this gaping chasm in which a huge group of defendants fall into. Anybody who is not arrested, like I said, for whatever reason, anybody who is arrested in another county on a charge that is not the qualifying offense, anybody who is released on bail, and I'm not even going to get into it, I think this court has already adequately raised the concerns about whether someone has the means or capacity to make bail and drawing that distinction, which is absurd. But just as a more general matter, if you look at the way in which the statute came into being, this statute followed an earlier amendment of Section 58 in 1992, in which the legislature attempted to allow bail commissioners, magistrates, judicial officers to consider dangerousness in conjunction with Section 58. And this court found that that was a due process problem, and rightfully so. But that was a much broader authority for individuals to detain dangerous people. That was any individual charged with any crime. Their dangerousness could be determined by a bail commissioner or a judge or a magistrate. And the legislature, that was their initial attempt to address this concern of dangerousness. So they obviously had this vast concern for public safety. After this court found that that was unconstitutional, Section 58A is enacted, and that has a much more targeted effect, right? We now have qualifying offenses that need to be committed. We need to have a full hearing at which a defendant is entitled to counsel, in which he can call witnesses, in which the Commonwealth must prove his dangerousness by clear and convincing evidence. I think it's important to remember when we're talking about the ability to hold a hearing that we're not talking about detention. We're talking about the first step. Can a court, as a matter of protecting the public, have a hearing to determine whether no conditions of release can suffice to ensure that public safety? In the vast majority of these cases, and I think in Mendoza, this court said, we still prefer release on personal recognizance. That is the preferred disposition. And in lieu of that, the next most likely disposition will be release on conditions. Detention is the most extreme step, and this court should not deny judges the ability to even evaluate whether that extreme step is necessary just because a defendant comes to court in a particular manner. The manner in which a defendant comes to court has no bearing on whether they're actually a dangerous person, whether they're going to go back home and beat their wife, whether they're going to go back out into the community and continue a trend of gang violence that causes innocent people to be shot or hurt or whatever. That is the driving force behind 58A, not whether or not a defendant will default at their arraignment. There's no indication that that was even a remote consideration of the legislature in passing this statute. What is clear is that this statute is not a model of clarity from a language standpoint, but I think it is clear that what the intent of the statute was to enable these individuals to be evaluated by a court, not by a bail commissioner who is precluded from even considering dangerousness. And I think that just raises another specter of how absurd this is. To suggest that just because somebody is arrested during a period of court closure, that a bail commissioner whose only purview is to determine whether they're likely to come to court can make a determination. Not even make a determination, but I mean, if you're calling a bail commissioner, which you're entitled to do, police can't even preclude you from doing that if they have concerns under this court's decision in Hampy. The majority of people are getting bailed. Bail commissioners are instructed, as my brother said, not to set unreasonably high bail. So most people, if they have the means, are going to get out. And so to conclude that because somebody makes a determination about likelihood to appear, that determination should subsequently preclude the Commonwealth and the court from making this public safety determination makes no sense whatsoever. That is completely absurd and contrary to legislative intent.
Right now it says when a person is held under arrest for an offense, I raised the possibility of what it meant was when a person has been arrested for an offense, and you say, no, that's actually not right anyway. So what, I mean, that's not right too. What did you say, but what do you say the legislature meant when it said when a person is held under arrest? How would you have, what do you say reflects the word, give me the wording that reflects the legislative intent.
I think there are 2 points to that. The first I would say is that if you look at subsection 2 and subsection 4, although subsection 2 merely speaks about upon a person's appearance before a court and motion of the Commonwealth, the court shall hold a hearing. And then it refers you to subsection 4 for the provisions of that hearing. And I would submit that although we have this first sentence in subsection 4 that talks about held under arrest, the salient provisions of subsection 4 are the second paragraph that talks about whether you're entitled to counsel, how witnesses will be called, what the standard of proof is. So an alternative interpretation could simply be that section 2 and section 4 create separate authorities for courts to hold hearings. That subsection 2, for example, authorizes a hearing for any defendant charged with a qualifying offense in subsection 1, and for some of them arrested and charged pursuant to that language, but not others. and then they refer you to subsection 4 for the parameters of that hearing. Subsection 4, on the other hand, refers to defendants who are held under arrest, and that requirement is that the hearing be held immediately because they're already in custody and we don't want any further delay. But that's a completely alternative interpretation. As a more general manner of interpreting what the legislature intended, though, and the reason the Commonwealth makes this broader argument is because, as I said, the manner in which somebody comes to court, right? If and I think Justice Doyle, in his decision that was affirmed by the single justice recently in Corthell, made this point quite eloquently. If I am a serial batterer and I beat the pulp out of my wife, and I have the common sense as somebody who's been in the criminal justice system before to go to my lawyer's house, tell him about it, and show up with my lawyer in the morning, if an arrest warrant issued for me the night before, the fact that I was smart enough to evade the police and prohibit them from executing that arrest warrant has absolutely no relationship to whether or not I'm a dangerous individual who's going to further harm my wife when I'm released on conditions pursuant to 58.
So you're saying that the first sentence of Section 4 essentially requires an immediate hearing if the person is held under arrest?
Yes.
Well,
I think
what
that is
about
another alternative interpretation.
But what about the very next sentence? Because this applies to all cases. The hearing shall be held immediately upon the person's first appearance before the court.
So again, I think if you were to adopt this alternate interpretation, that upon their first appearance is read in conjunction with the first section of subsection 4.
Okay.
And that the subsequent provisions that relate to the parameters of the hearing is what Section 2. And I see that I'm getting some confused faces, but I don't think this interpretation is necessary, because I just think as a matter of adopting a reasonable interpretation where the defendant's narrow interpretation is absurd, it makes no sense to distinguish between someone for whom an arrest warrant issues and someone who the police are actually able to arrest, because their ability to effectuate that arrest, the issuance of an arrest warrant reflects the urgency and the concern of law enforcement that this individual is a danger.
Means what?
I'm sorry?
Held under arrest means what?
Held under arrest means you commit a reasonable interpretation of that is consistent with legislative intent means you commit a qualifying offense and either are arrested in conjunction with commission of that offense or an arrest warrant issues for your, I'm sorry?
You're alleged to have committed the offense.
Sure. You are alleged to have committed an offense and you are either arrested during the commission of that offense or an arrest warrant issues for your arrest as a result of the alleged commission of that offense. That is a reasonable interpretation.
Okay, so basically arrest or arrest warrant, you would still exclude those who were summonsed in.
With the exception of those crimes listed in subsection 1
Well,
that
you
do
don't-
not require.
We don't have to go there. We
I
don't
don't-
have to.
no, I would agree. I don't think the
because
court
there's
needs
a
to go
very-
that far.
Even if one accepts your argument, it seems to me there's a very strong argument that even for those felonies, you would need an arrest in order to get this
And
hearing.
honestly, I think as a practical matter, I think it would be the rare instance in which anyone who committed those crimes was not arrested or at the very least subject to arrest pursuant to a warrant. So I do think it's sort of a non-factor. But the Commonwealth's position is simply that this court should adopt an interpretation that actually gives meaning to what the legislature was trying to do in '94.
And if the person had been arrested but posted bail, that qualifies.
Absolutely, it would, for all of the reasons I previously stated about the bail commissioners simply do not assess dangerousness. And where somebody arrested during court hours would immediately be brought to court and subject to a dangerousness hearing, the fact that somebody who's not considering dangerousness elects to release them should have no bearing on whether that hearing can take place upon their first appearance.
All right, thank you.
Thank you very much, Your Honors.